like you to talk to us about that High Court ruling. Now, how easy is it going to be for us to recall our MPs, and what inspired Katiba Institute going to court?
Maybe first I should define what recall is, which is having the power to remove your member of parliament, or even member of the county assembly before the period for which they were elected expires. Now, that provision is in the Constitution, Article 104, and Parliament was supposed to enact a legislation to provide for the grounds and the procedure for doing that. And they were supposed to do that within 2 years. So between 2010, they did it in 2011, in the Elections Act of 2011. Now, the problem that we had with the provisions that they enacted is that it made it impossible, practically impossible, to recall a representative, a member of parliament, or a member of the county assembly if someone wanted to do so. Some of the things that made it impossible is that first, you can't recall a representative within the first 2 years from the time they're elected into office, and again you can't do that in the final year, meaning someone is left with just 2 years. Then there are 3 grounds. Now, one of the grounds is that violation of Chapter 6, Leadership and Integrity Chapter of the Constitution. The second ground was misuse of public resources and violation of the Act, the relevant Act, the Elections Act and the County Government Act. And that was not enough. You had to go to court for the courts to agree with you that they have actually violated those grounds. And that is when then you move a petition for which it has to be signed by 30% of registered voters within the affected constituency. That has to be done within 30 days. So it was very difficult.
So
and one other thing that made it completely impossible is that after, because there is to be a recall election and there is to be a by-election. Now, a recall election, for it to be valid, 50% of the registered voters must concur with the petition, which is, would you like your representative to be recalled? So getting 50% agreeing, that is a big task, because if 51% of the registered voters turn out to vote and 49% concur, still that is invalid. And
after all that work.
Yeah, exactly. So it made it completely impossible.
All right.
Yeah.
So what is the ruling saying right now?
So the court agreed on us on most of the grounds for which we were seeking redress. The first is it invalidated all the grounds on the basis that first, those were not the intended grounds. It's supposed to be a political process, not a legal process. So if someone felt that the representative was not representing them in parliament, for example, they're not appearing in parliament, for example, they're not speaking in parliament, they're not coming to their constituents to consult with them, that should be able to form a ground for recall.
All right.
Not having violated other laws which on their own are catered for under the criminal law and such like things.
All right.
So the court invalidated the grounds, but also it invalidated that requirement that for the election to be valid, more than 50% of the registered voters need to.
So now is there another different percentage, or it's not?
No, it didn't. Now the court, that is the ground, the point which the court did not grant our request.
Okay.
Because we had requested the court to offer some guidelines to Parliament, stating that they should amend the Elections Act and the County Government Act, the relevant provisions, to within 90 days. Now the court said they prefer not, because Parliament had actually met its obligations under Article 261 and obligations to legislate within 2 years.
All right.
And so it's left it upon Parliament to
it's still gone back to Parliament.
Yeah, it has gone back to Parliament to amend. Now the point is they have to amend it according to the court ruling.
According to the
But again, we'll on our part as Katiba Institute and team, the other organization, we're still considering the options we have on the case. Yeah.
All right. Joshua, your thoughts on this one?
Now, my only concern would be, you would understand why the court will be cautious not to give into the little detail they're asking. The judiciary is not in the business of legislating. They are only meant to, 1, seek redress, and 2, to interpret. So the interpretation role is a bit narrow in the sense that it's a question of whether the law complies with the constitution, and that is what they answer them. But secondly, it now comes back to Parliament to now legislate, because it's a very dicey balance between two things. You don't want to make it so easy and so obvious. Now that, as Ambassador had said before, our country is a country that has little trust, especially public trust. So you're not seeking to have or to give leeway to mischief. For example, if we have a very competitive race and the opponent loses, for example, and the support base, let me assume it was a close race, and maybe up to 35% of the constituents supported a particular candidate, you are trying to ensure, beyond the percentages, don't make it easy for any loser to show up and just recall an MP. Let it be pegged on something substantive. My advice would be, I would love the same institutions, having brought this under public interest, proceed on with a very specific petitions and proposals to the legislature, which can be more productive. So as they pursue, for example, if they seek to appeal, the obvious way again would be take the same proposals and give legislature solutions. Show them how we can protect, but also still comply with the law, and make it possible to recall, but not make it so easy.
So easy to do that. Ambassador?
The law as it is impossible to get those fellows out of Parliament, even those who don't perform. So I like the intervention by the tool, that at least we bring it a little closer, so that the people who play mischief in Parliament, in the council, can be rid of.
All right, thank you very much, gentlemen, for that very interesting conversation. Yes.
Can I respond one thing to
in 30 seconds.
The thing is, if you compare with the British one, the British, you only need to raise 10% of the electorate within that constituency, and there is no recall election. If 10% sign that they need to recall the representative, then that is enough to recall a representative in a by-election. But the competitor again cannot create grounds. So if there are grounds, really, that is the creation of the affected person. So again.
All right, thank you very much for your insights. I've been speaking to Ambassador Jack Tumwa, former ECK Commissioner. Thank you very much for your time, Ambassador. We've also been having Ben Nyabira from the Katiba Institute. He is a program officer there. And last but not least, my far left, Joshua Kipto, who's a lawyer and a political analyst. Thank you very much for your time, gentlemen. All right, so we want to take a break here on the show. But before then, remember we have our Twitter poll. And when we come back, I'll be sampling some of the views. I've seen that coming in quite so many numbers. We'll be talking about your responses, and of course also we'll be having Zinzi Kibiku with what's trending in a few minutes, so don't go away, we'll be right back.